and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Particularly during a time of COVID-19, you will need a real good one. David Whiting is your talkback lawyer, Melbourne solicitor, dispensing free legal advice. Why? Well, because we like him. David Whiting, good morning. Great to talk to you again.
Good morning, Virginia.
Great to have you on board.
No, same secret location as last week.
Yes.
Haven't moved at all. I'm abiding by the Premier's direction to remain just with the people in my household. I've been out for 3 days. It's amazing.
It's sounding like an even more secret location these days, I must say.
Yes, yeah.
Now,
designed to stay that way.
However you're listening to me, don't have your headphones turned up too loud. I might get you just to adjust them down a little bit. That will sound better. Then I won't get too much of an echo of me back on the line. Hey, David, can I play you something? There was a press conference just before with Lisa Neville, the Police Minister, and the Deputy Commissioner of Victoria Police, Shane Patton, also used that press conference to just impress the gravity of the situation on all of us and how far the police are willing to go to protect the public. You might have a response to this. So here's Deputy Commissioner Shane Patton.
If we have a person who deliberately breaches any isolation rule, if they're, say, COVID positive and they know that, and they go into the community and they place someone at risk by actually doing that, we're going to consider whether or not we should use Crimes Act offences. Offences such as conduct placing a person in danger of serious injury, which carries 5 years imprisonment, or conduct placing a person in danger of death, which carries 10 years. These are serious indictable offences, but we're at a stage where we're going to say, we're open to considering that, but it will depend on the circumstances.
Serious indictable offences for breaching those self-exclusion rules. How about that, David?
Just don't see how they get there, Virginia.
Tell me why.
Well, because you have to have, my initial reaction is that you would need to fear that you had, or a reasonable apprehension that you had COVID-19. Because it's placing a person in decision.
Yeah, and I think he's talking, though, about the people who breach their self-isolation conditions. So let's say
absolutely.
They do have it, or they're suspected of having it 14 days, and if they come out, charging them that way.
Oh, yeah, I wouldn't have a problem. I think just the fine on its own probably not enough. Things are... Was it they saying that the traffic in the city has been quieter than it was on Christmas Day, when nothing's open. So it's interesting going for a walk this morning. Just nobody on the street, although a whole lot of people exercising around the park on their own.
Yes, I know that the parks are definitely full of... it seems to me like we've never wanted to exercise more in our life. I've never seen the tan, which I do regularly, never seen the tan so busy on a daily basis. It's all we do.
Well, I think they needed traffic lights at Princess Park.
Yeah, I think I agree with you there as well. Hey, you've got some family court advice on parenting orders, and this is very important because we've had many questions from split families and split parents about how they manage parenting orders during this time. What do you know?
Well, the Family Court, or the Chief Justice of the Family Court, issued a statement on the Family Court website last week. And if people want to look at the whole of the statement, they can see it at familycourt.gov.au and follow the media links. But basically it says try really, really hard to give effect to the family orders as they exist. As a first step, and if safe to do so, people should communicate with each other about their ability to comply with current orders.
Okay.
So I think that they need... Let's turn it around the other way. Let's not talk so much about enforcing the order. Let's talk about whether or not we can comply with it. So let's imagine I'm the custodial parent, I have a child. If in the event that the child gets an infection, am I a person who's then able to continue to look after them for the isolation period? That's where it starts to get really hard, and that to me is the risk. And of course, we've got some state borders closed. It gets messy.
But comply as much as you can with the orders. So keep the visiting going where it's safe. If no one in either household has an infection, if someone in one of the households, as you say, has an infection, then surely you're within your rights to say, look, I know it's your weekend, but that just doesn't seem right to send the child over to the house where there's an infection.
I agree with the not sending. I don't know. You've got a legally enforceable order. To me, that's a very good reason for refusing to comply with it. But the other recommendation that the Chief Justice makes is that you ought to reduce as many of any agreements or discussions that you have to writing. So whether it be by text message or email, particularly if you reach an agreement, because in the event that there are enforcement arguments in the months to come, those kinds of things will be very important.
Our number is 1300 222 774 if you've got a question for David on our Talkback open line. And Lorraine in Parkdale is first up today. Hi, Lorraine.
Good morning, David, Virginia.
Go ahead.
We had a holiday book which covered the complete tour package, which was flights, cruise and accommodation in hotels. We've been offered a full refund on airfares and the cruise, but all they've offered us on the hotels and the day trips is a credit note. Do we have to accept that, or are we entitled to a full cash refund?
It will depend, Lorraine, on what the deal was that you struck with the tour company. And if you were to look at, I've booked accommodation on websites in the past, and some of them will offer you a refundable option, and some of them will offer you a different price that's not refundable.
Okay, right.
So, I was all set to go overseas early in March, and I cancelled my trip not because I was particularly worried, but I was more worried about what I might bring back to people I cared for when I got back. And as a result, I lost an airfare that was not refundable.
We got the airfare back, less cancellation fee, so I suppose we did pretty well.
Yes.
Yeah.
So have a look and see what your deal was with the hotel and find out whether it works.
Okay. And another quick one, we had to purchase a visa to visit Jordan, which was over $100 for one night. And I emailed the embassy and they told me visa fees are non-refundable. And I just think that's a bit grim. They've closed the borders. We didn't cancel.
Oh, I think that's just
Oh, you can't leave. My view would be for $100 I wouldn't have the argument.
Okay.
And it's probably something you would need to litigate in the courts of the Kingdom of Jordan.
Good luck.
Right, okay.
Yeah. Lorraine, I just call that the cost of wanting to get out in the world and travel, and the price you pay when things go haywire or they don't go right. But the legal response is probably a better one. Gordon in Parkdale, good morning to you.
Good morning, Virginia. Good morning, David.
Go ahead.
Hi.
5 years ago, we had a renovation done on our house. The builder was in charge of getting all the permits for it, and he organised all that sort of stuff. A couple of weeks ago, we got a letter from a building surveyor saying that they had gone through their records and found that there had been no completion certificate done on our house. They included an invoice for $4,200 to renew the lapsed building permit so that they could then do a completion certificate. Now, at the time, I remember that the builder said he was going to organise the final inspection of the property. We followed that up at the time with him. Someone came, they looked at a few things, they said this needs to be done, the builder did them, and then they went off. That's the last we know of it. What is our liability 5 years down the track?
Same building surveyor, is it, Gordon?
I think so. I mean,
Okay.
I had to dig through my record to find anything referring to that building surveyor to say that our builder had engaged them. I don't have any receipt to say that we ever
I
engaged
must
them and
say,
paid them.
the building surveyor is an interesting situation. Gordon, technically you engage the building surveyor. It's normally that the builder will find the building surveyor for you, but it's an engagement that you make. So you have a claim with against the building surveyor if your evidence is that they have failed to... go back to your builder. See if the builder's got the records of the final inspection and the non-production of the certificate. Builder's gone broke?
The builder has shot through. He's absolutely disappeared. I've looked everywhere for him. I've called the numbers that I had for him. His office line doesn't work anymore.
And the final assessment was never done to even get the certificate? Or was
Well,
it?
I would assume it was done because someone turned up and did an inspection and said these little things need to be fixed. And as far
then
as
you'll
we
get it.
remember, my wife and I remember, that was done. And our understanding is that he was from that building surveying company.
Right.
I think that's
So-
probably right. But your
But
question...
then it's their records that don't record the fact that a completion certificate was done. It's their records that are at fault potentially.
No,
But they
Gordon,
they are saying that we are potentially up for a $1,000 fine for not having the thing done, or a $10,000 fine for inhabiting a dwelling that has not had a completion certificate done on it. It feels like blackmail, I have to say, the way they're phrasing it. If you don't pay us $4,200 to renew the certificate, then you are liable for these fines.
David, what should Gordon do?
Well, my first comment is it's possible that the inspector comes along and says, do these things and I'll give you the certificate, in which case you don't have a certificate, although some certificates of occupancy or final completion are issued with a list of outstanding matters. What I would do, Gordon, is I would probably pay them the $4,200, get the certificate, and then issue an application at VCAT, so you can have an argument about how much of the fee you can get back.
Are you in a position to pay that, Gordon?
No, we don't have $4,200, and I can't understand how they can actually do a final completion certificate on work that was done 5 years ago and take into account wear and tear. They don't have the original plans of the building for the extension that was done, as far as I understand. It just doesn't feel right 5 years down the track that they can do this. And they say that their records now don't show this after a review.
Okay, well, look, just to move things along. So, David, Gordon can't afford to pay that. What else would you suggest?
Well, the enforcements of those applications are done by council. So I can't see council taking you to task on this, but your difficulty will be you will at some point need a certificate of completion or occupancy, final inspection certificate, and you won't be able to get anyone other than this firm to do it for you, because what they've done is 3 or 4 inspections as the renovations proceeded.
I have no reports. I have no record of those inspections having been done by them.
Well, no, but they will have. So they will have inspected the footings and the frame and at a couple of other points, and this is the final. Now you can move into your extension.
Someone turned up to do the inspection. How do I know that they didn't do that and they simply didn't lodge it within their own system, and then down the track they see a way to get another $4,000 out of me?
I don't think it's going that. I can't see a firm doing that to you. What I can suggest is that you go through your records as best you can and tie down when you think the inspection was and ask them.
And then go back to...
And the other thing you might do is do a search on the ASIC website, asic.gov.au, put in the name of your builder, and you might get some more information about where he is.
Gordon, good luck. We'll leave it there, and good luck to you. That sounds like a dreadful situation to be in. I feel for you. Bob's in Caulfield South. Good morning.
Hi, Virginia. I wonder if David thinks that various Australian governments might end up being vulnerable to legal action over the damage that's been done to their businesses by the restrictions that have been in place for the last few weeks. Seems to me that
there are
legal
a few litigation funders who are now amassing staff to see who they can sue. I do think that there will be a series of class actions. My problem is that I quite frankly see that what the government is doing is appropriate and proportionate.
Yeah, but in 2 or 3 years' time, when this might be hit in the courts, you'll have 20/20 hindsight, and somebody might be able to argue that a particular decision was not so well thought through and unnecessary. Yep. And did harm to their business without good public health benefit.
Does the state of emergency status provide cover for that, David Whiting?
Yes, it does. I've had someone who's come to me and said, well, I was on a cruise ship and they diverted before coronavirus was a crisis. I want a refund. And I'm saying, well, it depends on the knowledge that everybody had at the time. So, Gordon, will it happen? Absolutely. Will they win? Who knows?
Good to hear from you. We'll leave that hypothetical there. Andra has called in from South Melbourne. Good morning.
Hi. I just want to clarify, what is the situation when you're a homeowner and your external wall is the boundary but the property next door, their title goes right to your external wall, and when, for
The
example...
boundary is the face of your wall.
Sorry?
The boundary is the face of your wall.
Exactly.
Yep.
But
You
I've
own
got
the
a
bricks,
window
but not
that
the area
opens
next door.
on to that land next door. So and there's currently construction work going on right outside my bedroom window, dust, noise, etc. Do I have any legal rights over what happens immediately outside my bedroom window?
No. Is the short answer. The slightly longer answer is that the building surveyor undertaking the work next door needs to consider whether there ought to be protection works. Protection works are works that if I'm doing a building contract and I'm building next door to you, then I need to be satisfied, as a building surveyor, I need to be satisfied that no damage will be caused to any part of a neighbour's property as a consequence of the work I'm undertaking.
But how do you ensure that the building surveyor, given that they're usually private, actually does that?
You ask them.
Okay, the other issue is...
Andrew, I think we only have time for one issue per person.
Okay, fair enough.
So, but good luck with that. David, I'm getting a lot of messages on text suggesting that the issue we discussed with Gordon about the missing certificate of occupancy could be a scam. And this is interesting. This doesn't sound correct to me. The building surveyor needs to provide a copy of the previous inspections and also the actual building permit. It just sounds fishy to me. And that's just one of many texts I'm getting. And that was from a builder.
So, Virginia, what they ought to do, when these certificates are issued, they're normally required to be lodged at council.
That's right.
So you should,
I've been through this myself.
Start council first. So if I'm a private building surveyor, I issue a building permit and a statement of certificate of final inspection on your property, I'm required to file those documents with council. So look and see what the council file's got.
You go to council first, wouldn't you? Just see everything that is filed there and then sort of work backwards from there.
Yep,
and
council's not going to issue proceedings against you tomorrow.
Yep.
They don't know.
Heather's called in from Essendon. Hi, Heather.
Hi, Virginia. Hi, David. Just a quick question, David. I've just had a new addition to my family. My niece has given birth to a little girl.
Congratulations.
Thank you. It's very lovely. I have done my will completely, but I'd like to leave her some money.
Yes.
Is that a complete change of will, or can I add just like I think it's a codicil?
It's called a codicil.
Yes, right.
A codicil, you can find, you could get a kit from the newsagent, you could go to the lawhandbook.net.au and there's a template for one there, but it basically says, I, Heather, from Essendon, make the following addition to my will. I put $5 for my niece. Right? In all other respects, I confirm my will and it gets witnessed, right? You weren't going to give her that much.
Oh, God, no, $250.
Okay.
I mean, not $250, $2.50.
No, I understand. It sounds a bit. I just put it in an envelope at that level.
Yeah, okay.
A very simple, straightforward. If you've got a lawyer who you've done a will with recently, the will be on their word processor. It's just as easy to put it in the will as it is to do a codicil. But you can do a codicil. The lawhandbook.net.au.
So I don't really have to go through the lawyer?
No.
No, you don't at all.
Okay, cool.
Good on you. Good to hear from you.
Okay.
Craig's in Healesville. Good morning.
Yes, good morning. What my query is, where we live on our property, we've got a long block, and on the other side we've got 5 units. It's a body corporate. We've got a number of trees on our fence line, and the branches overhang into their place, overhang the fence, and the driveway for the units is right next to the fence. So their overhang branches overhang into their driveway. Now, we've had that for about 7 years. We've never had an issue with them complaining about the branches. But what my concern is, if in the future they start complaining about the overhang branches and want them removed, who's liable?
They're your trees.
Yes.
They're in
our place.
Space. And can I point out, though, Craig, your trees will have grown somewhat in the last 7 years.
Yes.
Yeah.
But if I want to cut off the branches that are hanging over onto my property from someone else's tree, if they're over into the fence line into my property, I can cut them down, can't I, David?
Yes, you can, and you can even throw the branches over, but you might be liable if you cause any damage.
I think
And you
throwing them
might-
over is a bit hostile, don't you think?
Well,
I
if
wouldn't-
I
I
won't
wouldn't-
come and fix them.
I wouldn't have any issue with that. If they wanted to cut the branches down and throw them out of place, they've done that in the past. I wouldn't have any issue with that. But if they wanted to get somebody to cut the branches down and give us the bill, could they do that to us?
No.
No.
And they can't. They have no right to bring on a contractor to incur a liability.
No. And if the branches actually broke, like in a storm, if the branches broke in a storm or wind, and they fell onto their driveway, would we be liable for if they wanted? I would go. In the past, I've went over.
No, we take your point. Liable for damage, David?
Craig, let's not worry about them falling on the driveway. Let's worry about them falling on a car parked on the driveway. As a general proposition, that would be your problem.
Beg your pardon?
If they fell on a car and damaged the car, the starting proposition is it's your problem.
Your problem, your tree, you're liable. So watch out how far those branches stick out. Great to hear from you this morning, David. Thanks so much for that great advice.
Thanks, Virginia.
David Whiting, our well-known Melbourne solicitor, dispensing free advice there.